I am not. Forgive me. One moment. My name is what you asked for?
I did.
No, I'm not Peyton Ansley John Milton. I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Rights, and he does not wish to be represented.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, that language doesn't make any sense. So
no, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's
I'm not a person. I am one of the people. Thank you.
Okay. Thank you. All right. So for the record.
Right from the jump, he refuses to identify himself properly. This isn't just nerves. It's a sovereign citizen tactic. They believe legal names in capital letters are corporations and not them. Wild, right? But here's the real kicker. Judges hear this all the time, and it never works. Would you keep your cool if you were on the bench?
I so swear, Your Honor. So this information comes from a report of Officer Evers of the Lacey Police Department. She writes that on March 31st this year at approximately 13:53 hours, she responded to an unwanted person complaint at a 7-Eleven store located at 2425 Marvin Road Northeast in Lacey. Dispatch advised a male was refusing to leave the store and was being disorderly, yelling at staff. On arriving, Officer Evers contacted staff, who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Advised that he was intoxicated and belligerent. They advised that at one point the male stated he would be waiting outside when they got off work. The staff advised that they asked the male to leave multiple times and he refused. They also advised that once they called the police, the male returned to his Toyota 4Runner, and the license plate is provided here, and then that it was parked outside the gas station. The staff provided a prepaid phone and a charger that the male had left on the floor inside. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was too drunk to be held accountable. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property since he...
Listen to that, I'm not a person. One of the people. It sounds clever until you realize courts don't play by fantasy rules. The judge does something smart here. He doesn't argue, just locks him in as both agent and person so the case can keep moving. It's like cutting off a chess opponent's escape move.
Presented by counsel, is that correct?
That is correct, Your Honor.
So let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice. But I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that information, actually.
So not being an attorney, you understand that if you represent yourself, the court cannot assist you in recognition of the fact that you're not an attorney. So you will end up missing things you're supposed to do. You will do things you're not supposed to do. And all of those things will likely work to your detriment. So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them I think it's a foolish decision. You, however, have that right, as I pointed out. But I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
And there it is. The sovereign mask slips. Forget grand constitutional battles. The real story? Public intoxication at a 7-Eleven. This is where the case turns from big legal theory to sad everyday reality. Question for y'all. Does knowing the backstory make his courtroom antics tragic? Or just frustrating?
We just resolved that other case on the 22nd of March. That was done in custody. $1,000 was the hold at that time. The city's argument for that bail was based on the nature of that case being an assault, as well as, and I think most importantly, the outstanding warrant out of Skagit Superior Court. That warrant is still active. We're here with, even more concerning circumstances now with another charge. City's request is $500 bail on each case for a total of $1,000. Law-abiding behavior, no contact with the 7-Eleven on Marvin Road, and no consumption of alcohol, marijuana, or non-prescribed drugs, nor frequenting of bars or taverns, as alcohol does appear to have been a factor in this newest case.
Has anybody checked to see if Skagit County has been contacted regarding?
I don't have any.
The judge is practically begging him, don't do this. Get a lawyer. Self-representation is like showing up to a gunfight with a paperclip. But sovereign citizens? They see lawyers as part of a conspiracy. Here's a thought. Do you think the judge should force counsel in cases like this? Or is self-sabotage a personal right?
In time, I believe I'm supposed to request a voyeur of the body cams.
Like I said, I can't represent you. You're going to have to figure all that out yourself for purposes of today.
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court order.
Read your form on your constitutional rights. Officer there. Let's present Mr. Milton a copy of the rights form and have him read it. He and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of it.
Okay. Why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
And there's no victim in this alleged crime.
Okay. I know. All I'm asking right now is for you to read the rights and tell me that you have done so.
Would you please silence yourself? Forgive me. I have completed the reading, sir.
All right. Thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly. Request being released on personal recognizance, and the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was not in possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key. Unless you would allow me to fill in some details that they failed to read me my Miranda rights, and I wasn't taking a statement from in both questioned cases in question.
All right. So what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
I was never aware of that.
Right. Which is one of the reasons you don't want to represent yourself, but I've explained that to you now. But I just want to make sure. So you still wish to represent yourself?
Absolutely.
Classic mistake. He thinks Miranda rights apply everywhere. Quick legal insight. Miranda only matters when cops interrogate you after an arrest. It doesn't erase charges. It just limits how your words can be used. But see how he latches onto magic words to try and escape? That's sovereign citizens thinking in action.
$1 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store. No criminal law violations, not consume any alcohol, marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
If the minimum that I'm allowed to throw on a bail is $300 and I have to bail out for 2 things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer to impossible this time around.
You may know from your history that the bail here is usually 10% of what's ordered, so $50 on each case is what a bonding company would want.
Cool.
whether that
Well, I have
changes anything or
$100.
not.
Isn't that
Okay, all right. And at the pretrial hearing, you will have received information from the city prior to that as to any offer to settle the case. Just so you know, you don't have to accept it. But they will be contacting you to give you whatever offer they have, and then you'll tell them, the court at that time, whether you wish to accept the offer and enter whatever arrangement is made, or whether you wish to go to trial. So that'll be what we discuss on the 24th.
awesome? In the meantime, will I be allowed 4 to 6 hours of unhindered internet access so that I can represent myself?
Yeah, I do not regulate the jail, so you're going to have to talk to the folks at the jail.
If you write it as a court order, I'm certain that they will be more likely to comply than if you don't.
Right, I'm not going to write it as a court order. Like I say, I don't mess with how the jails run their jail.
Did you catch that? After hours of word games, he finally admits his name. That's the moment the sovereign facade collapses. It's a small but powerful reminder. No matter how much jargon or fantasy is thrown at the court, reality eventually wins.
On a side note, if I may, Your Honor, during intake, and I might preface this with, I have gone to anti-kidnapping training. I was inhumanely subject to what I would define as torturous actions. It was by C.O. Patero. I have nothing against the man, but he only sought to escalate a situation physically that could have been de-escalated with a verbal warning, a verbal, hey, knock your stuff off, a verbal. And I was completely compliant physically, as you can see on camera if you look in holding C on the night that I was intaken. And when I was asked to be picked up and seated, they had refused and told me on their paper that they checked on me every 15 minutes when I was checked on about 3 times the first 2 hours and about twice in the last half an hour. So
All right.
I was supposed to sign. I was also
All right,
told.
so hang on just a second. Is there a deputy there near you?
Yes.
Ms. Langley, where do we know where the document is that he?
It's in the system it's in the system somewhere, miraculously.
I'd love to read what I'm signing.
Yeah, that's
We like
Mr.
that
Milton,
too.
that's entirely reasonable.
Yeah.
Mr.
Yeah, I
Short,
can
know
help.
where it is?
Yeah, well, it just locked me out. It's in today's 1:30 negotiations folder.
Okay, I see. And so is it in the defendant's folder now? So the clerk Ms. Garza just moved it into the defendant's folder. So Mr. Milton, you can go ahead and taken out to, if there's a deputy there, tell him it's, can he or she come on camera? So basically it's in the defendant's folder in the computer. So if he can get out there and take a look at it and sign it and then just bring him back when he's done, that's fine.
Okay. Cool.
Take all the time you need there, Mr. Milton.
Thank you so much, Sam Meyer. Your Honor.
Hello, Mr. Milton, again.
Hey, Your Honor. It says I won't be able to enter in any evidence after I sign this, and